Morning, everybody. It's nice to see so many people here in person. I know we've been doing a lot of Zooms and hybrids, so it's nice that people are starting to come back in person. I'm Lindsay Nadeau. I'm a partner here at Reno in our employment group. I practice administrative law, which basically means representing employers before a variety of state agencies and anything they might run into: Department of Labor, Employment Security, Human Rights Commission, workers' comp issues, all of that. Hopefully also advising companies so they avoid having run-ins with state agencies. But then when they need a little help, we're there as well. And then my colleague Sam Fuller is in our corporate department. We have a large corporate transactional department. And so Sam oftentimes, and you can introduce yourself, Sam, will focus his practice on the employment aspects of corporate law.
Yeah, so I'm a corporate lawyer and an employment lawyer. Employment issues often come up in our transactions, whether it's compliance concerns or taking on new employees at hire or at a closing of a transaction. So my practice, I do dedicated employment advising when it comes to actually getting in trouble and being before the state agencies. You'll want to talk to Lindsay, not me. So.
And we're both, actually, I should mention, we're both barred in New Hampshire and Massachusetts. A lot of our clients have, as a lot of companies do these days, employees in multiple states, and whether it's because they're working remotely at home in a different state or they're actually physically located at a work site in another state. So that's something to keep in mind too. So I thought today, and let's see what we can do here. So you do have copies of the slides, and I think, Amanda, you'll be able to send them out to everybody after too if you can't read the teeny tiny font on the slides. But really, we're going to focus today on general overview and best practices, and then talk about it seems like a ping pong ball bouncing around at the federal level of rules with the U.S. Department of Labor. And so we'll talk about non-competes, wage and hour issues, overtime, all of that. And please ask questions throughout along the way. We hope this will be more of a discussion. So what we're seeing generally in employment law trends are nationally, we have, I'd say, a heavy regulatory hand coming from the Department of Labor. And also the NLRB, the National Labor Relations Board. And they're really being more proactive under the Biden administration. And so that's led to more rulemaking, which has caused a lot of headaches. And so employers are trying to keep up with those changes. And of course, we have a new administration coming in. We have some idea of what the new administration will look like, of course, because President Trump's prior tenure gives us a glimpse. So I do think it'll be different, but the question is what priorities the new administration will have nationally and, when they might implement those changes. States are also really being more proactive in terms of protective legislation. So that's equal pay and transparency laws. We're seeing more bans on non-compete agreements and restrictive covenants like that across states. And New Hampshire has joined a lot of those states. So in New Hampshire, we're seeing, it seems like each year, and a lot of my practice focuses on legislation down at the State House. Each year we see bills to restrict what employers can use in the hiring process as part of background checks, credit reports, that kind of thing, and an increase in privacy rights in New Hampshire. So we also have a section in here on the new privacy law. So those are just some big picture trends, and then we'll talk more specifically. You're all probably familiar with all of these employment laws that companies need to keep in mind. It's like the alphabet soup, right? FLSA, FMLA, ADA. And if Sam and I are using acronyms that you don't know because we forget, just say, what does that mean? But we're going to talk a lot today about the FLSA. But there's the federal laws and also New Hampshire specific laws. In general, and here's some good news, New Hampshire generally follows wage and hour laws set by the federal government. So that makes it a little bit easier. A couple of reminders for hiring and onboarding, which is specific to New Hampshire, and most states have similar requirements. Employers have to provide in writing at the time of hire an employee's rate of pay and fringe benefits. And then you also have to send changes to rates of pay and fringe benefits in writing, and they need to be signed by the employee. We typically see this basically as an offer letter that the employee signs and accepts, but it's good to go through and check your offer letters to make sure they're complying with both fringe benefits and rate of pay. And then if you change any of those, make sure you get an updated signed copy. And you need to keep those for 3 years under New Hampshire law. So keep a record in the personnel file.
Lindsay, every time somebody's rate is updated, they need a new offer letter.
Every time their rate changes, you need to tell them in writing that their rate of pay has changed, and then they need to sign it.
Is an email acknowledgement acceptable? Like if you send it out electronically and they acknowledge saying, yes, I understand and accept these terms?
That should be okay. As electronic, I don't think we have specific guidance from the New Hampshire Department of Labor saying that, but as long as you can document it, I'm comfortable with that, right? The key is really just have it documented.
You're probably not gonna get in trouble giving raises if you're changing pay the other way.
Yeah.
You
We're
probably-
gonna talk about that later when it comes to overtime.
Right, but changing fringe benefits, even like with the beginning of the year, if you're changing
Yeah.
a benefit, you know,
Mhm.
then.
And that's why a lot of times the beginning of the year is a good time to update those employee personnel handbooks and have that acknowledgement form signed, right? And that's the easiest way to do it, is really to keep a copy of the acknowledgement form. In New Hampshire, this comes up a lot. So just as a reminder, this is the same as it has been, but wages on separation from employment are typically due in 72 hours. And I always say, rule of thumb, pay it in 72 hours. You can't get in trouble paying it too soon. So pay it within 72 hours and you'll be in compliance. There are different rules where if the employee gives a longer notice period, that then you can pay it with the next payroll. But really, I'd say the 72-hour rule is your safest bet. Your final paycheck also needs to include all wages through the termination date, but also you have to pay out unused accrued paid time off, vacation, sick time, if you customarily pay it or you have a formal policy to pay it. So if you have a written policy that says we don't pay out PTO, that's fine. You don't have to include it in a final paycheck. If by practice and custom you've been doing it or your policy says you'll do it, then it counts as wages and it has to be in the final paycheck. So that's where some employers will get napped.
Is that another one of the rules that if you do it for one, you have to do it for all? So if you pay out.
It's not one and all, it's a custom or practice. So it's sort of a general. So I'd say if you're doing it regularly or if you're
Tell
doing it
everybody else no,
separately-
but then you have a key person that leaves and you know, it's amicable and you decide to pay out the PTO, is that okay or is
That's
that not
okay.
allowed?
No, it's okay. What you risk is anytime you're inconsistent in how you're treating people, there's some risk, right, that somebody else will say, well, you didn't pay me for my PTO. And is it because I'm in a minority, I'm a woman, because of my religion, right?
Yeah.
And so that brings risk. So it's safest to keep things consistent, but you do have some discretion.
Okay.
So the question, so if we have a policy at my company where we have to have the employee give a 4-week notice, is that okay? That's.
No. So generally speaking, you can't require a certain amount of notice. You can say we encourage
Okay.
4 weeks of notice.
Okay.
And for those who give 4 weeks of notice, we will pay out your PTO. You can say that.
Okay.
But you can't say, you know, you're an indentured servant for the next 4 weeks. Right.
Okay.
And just remember also bonuses, if you don't have a written bonus policy, it's really good to add that into your handbooks, to have a written bonus policy saying bonuses are completely discretionary. They are not paid out until they are due and owing, and you have to still be employed at the time of payment to get it. Because a lot of people will, you know, quit and then they say, well, where's my bonus? You paid it out in, you know, February and I want my bonus, but I was there all through January. And you say, well, you have to be employed at the time we pay bonuses. So that's good to clarify.
You know what, gosh, sorry.
No.
And our bonus is still not protected under the labor law. In other words, if somebody quits and they were due a bonus, but they didn't complete the term of the bonus that was set, it's still not protected.
So it shouldn't be, but that's why you need a bonus policy that says that. Your best bet is to have a clear bonus policy that says that, because they could be considered wages in certain circumstances. So you just want to make sure they're not considered wages.
I do performance bonuses. I'm a cleaning company, so I do performance bonuses.
Yep.
Do they have to be done same as like with every single person based off of a policy, or can it be done by my discretion?
It can be totally discretionary.
Okay.
Mhm. Yeah, you just want your policy to say it's totally discretionary.
Okay.
And we have, if that's something you need samples of, that's something we draft, you know, and can work with you on.
Okay, thank you.
So New Hampshire's overtime law, again, it follows the federal law. I'm gonna speed up because I'm taking all of Sam's time. So the main difference between salary and hourly is really just that if you're salaried, you're not necessarily clocking in and clocking out, and your pay doesn't depend on if sometimes you have a longer week or a shorter week, all of that. So overtime has to be paid for those hourly non-exempt employees at a rate of 1.5 for any hours over 40 in a work week. The employer has the burden to keep a true and accurate record of all hours worked and all wages paid to each employee, and that is on the burden of the employer. So make sure you're keeping those pay records for at least 3 years. That's New Hampshire law. So now we have the U.S. Department of Labor. If you're someone who watches our law blog, you will notice there's a lot of posts about the new overtime regulations that came out. So in April, the U.S. Department of Labor said, hey, we're going to bump up the salary threshold for white collar exemptions. There was a lot of anxiety, I'd say, for employers because the time period before implementation was really short. So the final rule came out in April, and then it was effective July 1st. So the threshold bumped up from basically $35,000 a year to $43,000 a year, and the exact numbers are there. I also stole this chart from somewhere online that was very helpful, so I put that in there.
A question about that. If you have someone working commission, so their salary is below that threshold, but their commission takes them way above that threshold, does this affect them?
It does. So commissions, so what you're looking at is your regular rate of pay basically, and that can include commissions. So you really need to look at as a whole what the employee was making.
Okay, just so I understand. So if the salary is $35,000, but they're earning $35,000 in commission, then this would not affect them.
Right. And so what you're and we're going to talk about. So right now you need to meet both a salary test and a duties test. So it depends on what the job role is too. But generally speaking, commissions, if they are regularly occurring, you want to look over time at what the annual salary of the employee is and consider commissions, consider bonuses, things like that. And then it would have gone up again January 1st, which actually is just right around the corner, to $58,000 a year, basically. And then it was going to automatically increase every 3 years. Then on Friday, and it's a good thing I hadn't done these slides yet. So a federal district court in Texas said, no, and struck down the rule nationwide. And so sometimes courts will strike down the application of a law just in that case. This court, and this happened in 2016 by the same court, I think, struck down the whole rule, soup to nuts, across the country. And so it means we're back to actually the 2019 levels now. So July 1st, the first bump went up, and then in January, the second bump was supposed to happen. And now we've actually gone back down to pre-bumps. So we're back down to $684 a week. And remember, this is just a salary threshold when you're trying to determine if an employee is exempt from overtime. So this is really looking at, do you have to pay an employee overtime or not? So there's a lot of speculation about whether the Biden administration will bother appealing the court ruling to the appeals court, or if they'll just say, look, we're on our way out, we'll let the next administration deal with it. I would suspect the Trump administration, if left, will not appeal this decision, and the rules will not go forward under the Trump administration. If I had a crystal ball, that's probably what it would say. But again, you never know. So we'll keep an eye on it.
I don't think an appeal would be likely to be successful because Obama tried the same. The Obama administration went through the same increase knocked down by a court. And I don't remember the full history of the appellate decisions there, but I mean, I was surprised. I was waiting for this to happen. Luckily, it happened right before.
It's a shame.
It's with some clarity.
Yeah, and you know, it's a shame that we didn't get a court decision before the July bump, right? Because so what a lot of, and we're gonna talk about this, a lot of employers took had to reclassify employees who were in that gap and said, I'm gonna make you actually hourly non-exempt now. You used to be exempt salaried. I'm now gonna bump you to a hourly non-exempt position. You're gonna have to start tracking your time. You're gonna have to file for overtime. Right, that creates a lot of headaches, and it's hard for employees too, who say, wait a minute, why is this changing all of a sudden? My job didn't change. Why is my compensation changing? And now employers are going to be faced with that group of employees who maybe had to shift around. Do you switch them back? Do you leave them? What do you do? So that's really a case-by-case decision you're gonna have to make as an employer. One thing to keep in mind, and this is just, we're gonna sail through this part, and you can ask us questions if you have any. The duties test to the exemptions, the white collar exemptions, did not change. So all the new rules did was impact the salary threshold, but it did not impact anything else. Here's a list of the white collar exemptions. These are the executive, administrative, and professional. Those are typically the ones we see the most. Sometimes you'll also see highly compensated employee. And I put in here some general rules about white collar exemptions. I won't get into too much detail about them. But basically you have to be paid on a salary basis. You need a payment of that minimum salary threshold, and then you have to meet your primary duties test. So that's typically what you're looking at. Here are the different primary duties tests in a nutshell. You can take a look at those. Again, these are the same as they have been, but it's just a good time to go back and look through them and make sure that you're properly classifying your employees.
And some of them, I don't know if you'd agree with this, but they're a little bit harder to meet than you might think. Just, oh, it's an executive role or it's an administrative role. There's, you know, you have to look at the exact language because it's a little bit tight and not exactly what you might expect it to say.
Yeah, one of the things we often see is people say, well, I'm the general manager of the Concord store. I'm exempt, I'm a manager, right? I'm a executive. And that's really not what it is. Being just a branch manager isn't actually enough to meet the executive. That might meet other, you know, like the administrative or the professional exemption. But really, when you're talking about an executive, you're talking about like the director of marketing for the whole company. That would be an executive. The marketing director for a branch office, probably not going to meet it. So it really does depend on each job description. And that's also why it's important to have your job descriptions written down and reviewed and updated, and to actually check with your boots on the ground workers to say, hey, here's the job description. Is this actually what you do? Right? Have them look at it and have them tell you what needs to be changed. So again, just talking about the changes in the overtime rules, what do you do now? If you hadn't already done a job classification audit, you should probably just do another one and go back and refresh that and look at your positions and look at how they're classified and if they are properly classified between the duties and the salary. It's helpful as much as you can to have you know, things in writing, including workflow charts, organizational charts, because they help show, oh, this person is in a level of authority that they're exempt, right? They oversee this many people. Our disciplinary policy includes them having a certain level of authority. Those are all helpful to show. And that's something we can help review and draft if you need updates. Performance reviews, we just were doing our performance reviews at the firm. They're not always the most exciting thing to do, but they're really helpful and they're really good. And employees really appreciate getting feedback. So I would definitely encourage you, have a consistent and robust performance review process and make sure as part of that, the duties in each role are reflected in being addressed in the performance reviews too. And generally you can do them annually, semi-annually is even better. So again, you can look at changing positions back to exempt. Frankly, I'd probably just let the dust settle, keep things as they are right now and see what happens with the court cases. You know, I do think it's confusing for employers. It's also really confusing for employees who have been impacted. So, you know, you might want to ride it out for a little bit. And just remember, any changes in rate of pay have to be documented in writing and signed by the employee if you do change pay rates. All right, I will be
Right.
quiet now.
Nice slide. So the next topic we wanted to talk about is non-compete agreements. So similar to Lindsay, I was preparing for a presentation where I'd talk about this new rule, this federal rule that was passed and how it's changed the landscape entirely. And a court in Texas, actually, maybe the same court, I'm not sure, struck it down. And then we have a new administration coming in, and so we're not sure what's going to happen there. So I'm going to just kind of talk more generally about the state of the law, since I don't think it's going to change significantly anytime soon on the federal level, but we can talk a little bit about non-compete agreements, how to use them, other restrictive covenants that you can use that may be just as useful to your business, and New Hampshire law specifically.
Really quick, show of hands, do people use non-competes or non-disclosures or confidentiality agreements, that kind of thing? Yeah. Yeah. We get this a lot.
Yeah. Yeah, we'll get, they're a good idea, I think, for most businesses to have at least some sort of restrictions protecting confidential information. We see clients, on the back end of a situation and there's nothing in writing, and, it's a worse situation. And so it's a good practice, I think, in general. It's not a good practice to push non-competes out, and specific non-competes as the restrictive covenant, because they are much more difficult to get enforced by a court. And I think in general, if you have a big restrictive agreement that you serve up to an employee and it includes a non-compete that's not very specific to this employee or narrowly tailored, then the rest of the restrictions that you might have that might be useful and important to you might be, there's some doubt cast on whether those should be enforceable too, and you kind of are on your back foot as an employer trying to enforce and protect your business in some way. But anyway, so this is more high level background here. So, non-competes are a restrictive covenant. A covenant is a promise to do something. Restrictive, adding that word means, it's a promise not to do something. Non-compete is typically a agreement that an employee enters not to work for any competitors or in a competitive industry for some period of time after termination of employment. Typically, they're entered at the beginning of employment in an employment agreement, a full formal employment agreement. I'd say that's less common. The more common structure or hiring package would be an offer letter with a separate, restrictive covenant agreement. Here's the restrictions that you have to sign to become employed here. And then the last bullet here is just, they're not all enforceable, and state law historically and generally determines whether they're enforceable. This is sort of this gets us out of the employment realm for a second, but I think it's important because I see a lot of client confusion around this. It's the same word, non-compete agreement or non-compete, but you oftentimes in corporate transactions, you enter into a non-compete at closing. And in that non-compete agreement, the seller of the business is agreeing not to compete with the business they just sold for some period of time after the sale closes. So these are different in a lot of ways because courts and states look more favorably upon these restrictions. You're not hiring somebody and as a condition of their employment, making them agree not to work for anybody in a similar field for 2 years after employment, for example. Here, it's a seller of a business. They're getting, hundreds of thousands or millions of dollars for their business. The buyer wants to protect that investment and the goodwill of the business that they just bought. So courts are more flexible, and they can last for up to 5 years. Sometimes longer, but 5 years is pretty common. And I'm just flagging this because sometimes people hear about, a 5-year non-compete or something like that, or they think that they conflate these two contexts that are very different. So it's important to just keep those clear. All right, so these are the federal developments to non-compete law that I thought would be the main thrust of this presentation, but really I think are not as important anymore given recent developments. So two federal agencies have really made some efforts during the Biden administration to curtail the use of non-competes in the employment context. Going to leave the sale of business context behind for a minute. So the FTC, the Federal Trade Commission, passed a rule that banned non-competes nationwide, all non-competes in the employment context. It only accepted a very small sliver of existing non-competes with basically like your CEO or the highest level employees of, of public companies, really. It was very narrow exception. So this happened in April and, we were all gearing up and there's a lot of excitement, in the employment law world. This was really going to be a sea change because like I said, every state right now, the status quo is every state kind of has their own view of what's enforceable in terms of non-competes. This was going to really flip it on its head and there was going to be a ban nationwide. At the same time, in the last couple of years, the National Labor Relations Board, their general counsel, issued these memoranda, which basically is, her understanding and position on the law and what she thinks violates the NLRA, the National Labor Relations Act, which is the law that they're charged, that, body is charged with enforcing. So there were two memoranda that came out that really cast doubt and suggested that non-competes in the employment context could violate Section 7 of the National Labor Relations Act. That, you might hear NLRA and think, well, I don't have a unionized workforce, that doesn't apply to me. It actually does apply to unionized and non-unionized workforces because Section 7 is about employees' rights to engage in what's called protected concerted activity, which is basically talking to each other about the terms and conditions of their employment and possibly forming a union or, engaging in collective bargaining. So even if you're never had union issues, your workforce isn't unionized, certain things that come out of the NLRB do affect all workplaces. So.
And it's interesting, we are seeing in New Hampshire an uptick in union activity too. So it is good to make sure that as an employer, what you can and can't do if employees are talking about unionizing. And if you hear scuttlebutt about unionizing, you pick up the phone and you call your lawyer. That's like number one, okay?
Yeah, don't follow your instincts, probably,
Yeah.
right?
Yeah.
So starting with the FTC rule, federal judge in Texas, like I said, set it aside, shall not take effect. It was slated to go into effect in September. Nationwide, this ruling held that the rule cannot go forward. At the same time, another judge in Florida, or around the same time, blocked the rule from going into effect in a particular case. Which is less important, but just pointing it out because there's now two appeals that the FTC has brought to both of those decisions, and they're in different circuit courts of appeal. So there's the possibility there of a potential split, and then you go to the Supreme Court if there was a difference in the rulings. That assumes that you have an administration that's pursuing these appeals, which I don't know actually, because my reaction was it's a Biden administration sort of rule. Trump's going to abandon it. I've read a little bit recently actually, and some people aren't really sure about the Trump administration's position on non-competes. It's not a cleanly partisan red-blue issue. if you look across the states in the country, you do have like your Massachusetts and your California are very strict on non-compete. So you'd say, okay. And then the Biden administration tries to ban them nationwide. So you might say, okay, this is a, blue, liberal policy. But then you have some red states that ban non-competes because they view it as restricting people's rights to make a living and work. So it's not really a neat, clean partisan issue, I don't think. But at the same time, most of the people I'm reading online, I won't try to read tea leaves too much. I'm kind of reading other experts and what they think. Most of them think it's unlikely that the appeals will be, vigorously pursued by the Trump administration. But we'll see.
And I think even if they were, it certainly wouldn't be at a broad brush. All non-competes are banned. You might see like New Hampshire just passed the low wage worker ban on non-competes. You might see something more like that. But again, it's up in the air still.
Well, yeah, that was part of, I think the Texas decision was like, this was too broad. The rule was not, specific to industry or particular concerns. So, when an agency makes a rule and kind of is trying to act as Congress and like changing policy completely, that's when these things get struck down. The FTC gives, the FTC Act gives the FTC the authority to, I think it's regulate unfair methods of competition. And so they use that to try to, change the landscape for non-competes nationwide. And so, even if Trump wanted to pursue the appeals or his administration did, I think there's a high likelihood that the courts of appeal would agree with the lower courts and, this rule won't go forward, but maybe something else. I don't know. So those are the reasons that might not matter. The reasons that the NLRB memoranda that cast out onto non-compete clauses under a different, federal law. The reasons that these face headwinds is because, again, there'll be an administration change. The memoranda are the positions of the acting general counsel of the NLRB. Every indication is that she will be removed and Trump will replace that person with a new general counsel, just as Biden did before in his administration. And then that new general counsel, what I'm reading and seeing and hearing is that they'll probably rescind these past statements of policy and enforcement policy. And it's easier to do that because these memoranda are just a position statement, kind of a, here's how we're thinking about these things, here's how we're going to pursue them as an agency. I'm sorry. Did they not hear us?
No, I think it's just one person.
Okay. So yeah, I think I say unclear here. I think from what I'm reading and seeing, it's likely that we won't have the NLRB being a real impediment to non-compete agreements. So no, yeah, next one's good. So all that being said, so there was, there's some federal pressure on these contracts, these agreements that employers have used with their employees historically. It's not looking like the federal law will be the big mover in the next 4 years. It might be, we'll see, but for the time being, state law is really what you need to be looking at and thinking about when you're considering as a business, how you're going to protect your business and how you're going to restrict your employees. So New Hampshire has a few different statutes directly speaking to the enforceability of non-compete agreements. The top one here, the low wage worker prohibition is fairly recent. I don't know if it was this year or last
It
year.
was a couple years
ago.
yeah.
So across the board, you cannot enter a non-compete agreement with low-wage workers. People who are making less than 200% of the federal minimum wage. And then we have 3 different specific bans for nurses, physicians, and podiatrists, which Lindsay thinks they've got a good lobby going.
So, yeah, so it's kind of annoying, right? Because we have all it's a patchwork approach based on certain specialties. And having just been down at the State House, I can tell you it's just, different professions have associations and lobbyists, and so they get those kinds of things passed. We typically see them, as you can tell, in the healthcare field. And again, Dan will talk about other ways, even if you are in the healthcare field, they can't have non-competes. There are other ways to protect your business interests.
I have a question, if it's okay, about the low wage worker. How does that work with part-time workers that are either their second job or just their primary part-time? Because
It's your rate of pay. So it's just your rate of pay. So as long as you're, looking at the federal minimum wage is what, $7.25? So anybody making $14.50, if I'm doing my math right,
okay,
as a rate of pay, right? That's your,
Kind of,
okay.
I don't.
So you want to look at your hourly rate, really.
Yeah, it's not doing much work,
anybody
federal
getting away with
minimum
paying
wage change.
$14.50 right now for any labor?
Yeah, exactly.
Yeah, they probably don't have a non-compete anyway.
And you're
Yeah.
probably not, you probably shouldn't be trying to restrict them from
Yeah.
working for others.
Right,
I was able to.
thank you.
You want to just click it forward.
I'll be your van.
Thank you. Okay, so those are, so New Hampshire, I guess you could say, doesn't have a, blanket non-compete law. Massachusetts does. California does. They ban them. Other states do, but New Hampshire has, like Lindsay said, sort of the patchwork. A few professions got lucky and, they can't be restricted by non-competes. So we have to look at, the common law, which is basically judge-made law. When a judge has a non-compete before them, they have to look at it and say, should this be enforced or not? And so there is a test that kind of comes out of the case law here. The 3 requirements for a non-compete to be reasonable. Does it protect, or is it no greater than necessary to protect the employer's legitimate business interests? So I think the no greater than necessary is sort of interesting there. That's kind of the tailoring. You don't want to say you can't work for any competitor in the United States if you don't do business throughout the United States, right? It should be, specific to protect your actual business interests. Below there are the examples of what legitimate business interests can be. So the goodwill of your business, trade secrets, confidential information, customer relationships, and other business contacts. So other relationships that the employee might build, and it might be unfair. I guess the argument would be, if you're on the employer side, this person's really important. They know all about our secret sauce. They know all our trade secrets. Because they're working for us, this person has all these contacts with really important vendors and customers that make this business really run. And if this person left and kind of exploited all of that and started a competing business, that would be unfair. And if you can make that argument for a New Hampshire court, I think, and otherwise the agreement wasn't too long, wasn't too big in terms of geography, I think you have, an enforceable non-compete under New Hampshire law. The undue hardship and public interest, those are kind of, I feel like, squint your eyes, is this undue hardship? I guess that kind of gets to length, if somebody's restricted from working in their field for 2 years, that could be quite a hardship. And then public interest, I think, is where the judges say, do I like this or not? Do I think it's good for New Hampshire, I guess. The key points below there, I think those are really important if you're thinking about it, trying to get a non-compete with an employee. I think thinking about what the person's role, the position is, what are they gonna have access to, who are they gonna be talking to, how important to the business are they going to be, and what kind of competitive threat might that pose to the business. The duration, how long you're trying to restrict the employee post termination from competing. I think 1 to 2 years is, really, I think 1 year is what you should go for. 2 years, you're kind of pushing it, but I do know New Hampshire courts have enforced them up to 2 years. I don't know if they've gone farther off the top of my head, but and then territory, shouldn't, where they're restricted from working for a competitor should not be broader than where the business actually conducts business and has relationships. And then the scope, what are you restricting them from doing? It should be specific to the field that your business is engaged in, and you shouldn't be restricting them from doing something outside of that scope.
And I think the only other thing to remember for New Hampshire for a non-compete to be enforceable is that you have to give the employee on or before they commence work a copy of the non-compete agreement. Otherwise, it's just per se void. So make sure if you do want to enter into a non-compete agreement with an employee, you're giving them a copy before they commence working.
That's clear. So Lindsay and I were talking about this, and that's a lot on non-competes and how you could get them in New Hampshire. But I think a lot of the advice we give clients is that you can protect yourself in other ways that aren't subject to such strict scrutiny from courts and won't get you potentially bumping up against federal issues. And so the other restrictive covenants in your toolbox, this is a few of them. I think these are the big ones. Confidentiality restrictions. So you can prevent employees from using and disclosing your proprietary information. I think when you're drafting these or looking at your policies, maybe I think the words using and disclosing are important because you don't want an employee to be able to publicize something or tell a competitor. So that's disclosing. But using would be, if they have a customer list and they start dialing up, they didn't disclose any confidential information, but they're using it for a competitive advantage. So I think having the two words there is important. That's just kind of a pet thing of mine. Non-solicitation covenants. So these covenants are sort of similar to non-competes in some ways. You can restrict an employee, after employment terminates from soliciting your business's customers, clients, vendors, other business partners. These are also sometimes construed as non-interference. So you won't, go to a customer and talk bad and try to get them to stop working with the existing business, regardless of whether you're soliciting. So you can kind of draft it in a way that's a little bit broader there. And then employees or independent contractors, you can protect your business by restricting employees from trying to poach or hire their former coworkers to, try to create some competitor. And then non-disparagement is another one that a little less common, but if that's a concern of yours, you could restrict employees from disparaging the business or the business owners of your business. I will say you have to be careful on those. It goes back to the NLRA. If you're suggesting to an employee that they can't talk about their terms and conditions of employment or, share concerns about their employment, then you could run afoul of the NLRA. So a lot of times if we're drafting something like this, we have carve-outs that say, this isn't restricting you from engaging in protected activity under that law. So just kind of a drafting tip there.
Yeah, and I'd say the thing we see the most come up are probably the non-solicitation provisions. And so from my end of things, that's usually where employers call and say, we had to terminate an employee. We just found out they sent all these emails right after they were fired to all of our customers. And Or, they, did X, Y, Z, and now they've opened up shop a mile away and they're calling all of our clients. They're staying in touch with employees, which makes us uncomfortable, right? And so that's where those sticky situations come in. And a lot of times, if you have a non-solicitation provision and a confidentiality provision, it gives you a really good basis to send those problem former employees a cease and desist letter. And people may not listen when HR very nicely sends them a reminder of, hey, please, stop what you're doing. They'll take notice when it comes on law firm letterhead. I can tell you that. That's something we do a lot. Because it reminds them that you take it seriously and that you are going to protect your business. And so I do think that signals to people when you do have those unfortunate situations, and they happen, right? That you're going to protect your business and that you have counsel involved and that they need to just stop, just cut it out and everybody move on. And that really is the best case resolution in those scenarios.
Do these restrictive covenants work just like the non-compete where you need to have it before employment starts?
No, and so that's like what Sam was saying. So they're usually easier to enforce. They can be in your employee handbook. They don't need to be a standalone agreement. So commonly you'll see them just in the employee handbook. Also why you want to have your employee handbook acknowledgement forms signed by employees. And courts are more favorable toward the non-solicitation and confidentiality because you can see it's easier to see how it's protecting the business and not just being punitive toward an employee, right? You're really trying to protect your business. And so I think that's probably why courts like them a little bit more.
Yeah, the former employee can go work anywhere. They just have to abide by these kind of rules that you've laid out. And so that's where the non-compete is like, it's at its face, you can't go work for a similar company. A lot of the employees that are bound by them are, well, my skills are in this particular industry. I live in this particular area. And so you can see why courts and like I said, people from both political persuasions kind of don't love the non-competes. And I think, when the FTC non-compete rule came out, I don't know if anybody in this room heard about it separately. I think it did make some news and I think it was broadly popular. And I think these restrictions you can kind of do, you don't have to be, you do want to tailor it to your business and protect, protectable interests and be reasonable. But you don't need to think about every employee you're hiring and their particular duties and whether it's reasonable for them. I think you can kind of use these as a form that you have, a good form that you really like, and you just have all employees sign them. And maybe there's some exceptions to that, like part-timers who don't, but for the most part, you can kind of, it's a little bit simpler to implement too. And then you have that.
So I've got it dumbed it down where I have a form in my employee new hire handbook for every single one of these items because they don't really read the handbooks, right? And then they come back and say, well, I didn't know that, but it makes my employee handbook really thick, my employee new hire packet really long. So I don't have to actually do this. I can just leave them in the handbook and be like, hey, you should have read it.
So you can leave them in your handbook so long as you want to have them sign an acknowledgement that says, I read the handbook.
Correct. Yeah.
So then you say, well, you said you read it. You can't say you didn't know. Yeah, no, that's fine to just have them in the handbook, or you can have it as like a standalone policy.
And handing them, giving them electronic handbook is the same as giving them a paper copy.
Fine.
Do they have to acknowledge that they received it electronically?
I think any sort of acknowledgement, I don't think it needs to specify that it's electronically. I think you do just want some documentation of them say, I have acknowledged and I understand the following policy handbook, whatever it is.
Okay, thanks.
I mean, these agreements don't have to be too long, really. These can be like 3-4 pages and cover all of these restrictive covenants. And I think, if a client came to me and they had an issue with somebody soliciting, I think I'd prefer to see that they signed an agreement rather than say, here's what I have in my handbook. But that's just me, I think.
Yeah, perfect world, right? Everything's really buttoned up. But if you are finding it's just too much and people are, signing a million forms on onboarding, which they already are, have it in your handbook at the very least. All right, so I'm going to fly through privacy in the workplace.
Sorry.
No, we're good. This is good. I'd rather more talking than crickets. So generally, just speaking of privacy in the workplace, again, have a privacy, but have your policies specify that, anything an employee should expect, including you don't have, an unconditional right to privacy in the workplace. The equipment you're using, the software you're using, communications that are made on employer equipment or systems all belong to the employer. And just make sure your policies clearly say that. So that if you do have to part ways with someone, it's very clear what's theirs and what's yours. It doesn't happen too much, but sometimes you'll also need to maybe, look through belongings at an employee's desk or files or things like that. And so you want to have a really clear expectation that you don't have this right to privacy in the workplace. The U.S. Consumer Financial Protection Bureau recently warned employers about using AI with privacy matters. And so I think you just want to be careful if you are starting to use AI, and I do think that's something we'll see more and more of. Just keep in mind that there are some privacy concerns there. AI stores a lot of private information of employees. And so you want to just be really careful that you're abiding by all applicable laws, even when you're using AI. New Hampshire in 2018 passed a constitutional amendments that says individuals have a right to privacy, whatever that means. And courts really, there's been a couple small court cases, but for the most part, we really haven't had court cases saying what that is. So we will know more about that probably at some point. I don't know how to make this go away. Do you, Kristen? Oh, wait. Okay. So really, again, just be careful when you're using AI, especially if you're using it to help hire and vet applications. Because AI is still, I'll say, a little new, there could be biases in there that the AI technology is using that you're just not even aware of, but then you're the one as an employer who could be liable for some sort of discrimination claim. So again, just be careful. It could be really helpful though, right? We all know HR departments are really overwhelmed right now. If you are a small business owner, or you have a specific HR team, I'm looking at Lisa, one of our HR team members, they're busy. And so to the extent that AI can help us be a self-service tool for employees, that's exciting, right? So if an employee can type into, I don't know, Chat GPT or whatever it is and say, how much PTO do I have left? And then it says, you have 5 hours left. Would you like to request paid time off? And they say, yes, I would, please. I'd like tomorrow off. Right? Like that would ease up a lot of HR's functions. So it could be really exciting. I think it's just early to tell. Senate Bill 255 was recently enacted, and it takes effect January 1. And it basically says there's an expectation of privacy, and you have to be careful if your business is a covered entity. And basically, you have to give notice and let your clients and users, customers, opt out, basically. We do have a whole post about this on our employment blog, so I won't get into it too much, but part of why we wanted to mention it is because I think a lot of businesses think they're covered by this new privacy law, and it turns out not very many people are. I would like to call it feel-good legislation, probably. But as you can see, all of these entities are exempt, which is basically like everyone. So if you are wondering if your company falls under this privacy law, give us a call. And here are just the key provisions. Here is a law, and we actually have a employment blog that I printed out if you're interested in taking a copy. One of the new employment laws that were just signed is the firearms law. So this, again, takes effect January 1st, but it says that employers have to now, covered employers, which is pretty broad. It's basically if you receive any sort of government funding, awards, grants. I question whether, like, if your business got PPP money, if that means it might apply. Do I think it's retroactive? Probably not, but who knows? that you have to allow employees to keep their lawful firearm and ammunition in their cars out of sight. They don't have to be locked away, they just have to be out of sight. And so this covers a lot of different employers, and you have to, think about what your policies are for weapons in the workplace or safety concerns, and if those need to be updated. So keep an eye on that, because that is something new. And just remember, consistency is key. I have a little sign in my office that says, "But did you document it?" And that's like my favorite. I just point to that all the time. So you just have to make sure you're documenting things and being as consistent as you can. Visit our law blog for updates on non-competes, on wage and hour issues, overtime. Chris Cornog over there helps us write our law blogs and does a great job and keeps us all up to date. So it's really helpful, and you can check it out anytime. So questions? I know we're running out of time, but questions, anybody? I know that was a lot. So if you do have questions, I think our business cards are over there, but if not, I have some. Reach out, we're happy to work. We really enjoy working with employers and employees on these issues. Everybody's goal is usually to have a peaceful, cohesive workplace where everybody's working as a team as smoothly as possible. And so if you can get these pieces down, that just makes it easier for everybody.